to the Maximize Business Value podcast. This podcast is brought to you by Mastery Partners, where our mission is to equip business owners to maximize business value so they can transition their business on their terms. Our mission was born from the lessons we've learned from over 100 business transactions, which fuels our desire to share our experiences and wisdom so you can succeed. Now here's your host, CEO of Mastery Partners, Tom Bronson.
Hi, this is Tom Bronson, and welcome to Maximize Business Value Podcast, a podcast for business owners who are passionate about building long-term sustainable value in your business. In this episode, I am so thrilled to welcome our guest, Dan Schulman, an IP attorney with Vedder Price in Chicago. Dan and I are both members of a professional organization called Provisors. We recently met at one of our monthly meetings, and we talked last week about the importance of intellectual property and how your intellectual property impacts the value of your business. So I asked Dan to come on to the podcast today so we could discuss just that. Welcome to Maximize Business Value, Dan. How are you?
I am well, and the only thing I wish as an intellectual property attorney is that I could convince the Bears to be innovative with their offense.
This is recorded, just the day after that fateful night, when the Bear. Well, we won't say the Bears and the Rams.
It's a little bit like in '85, the Bears recorded the Super Bowl shuffle video the day after they lost to the Dolphins.
Oh, no. Oh, my goodness. Well, it was an interesting weekend for football. Our listeners know that I'm a big football fan. And of course, I grew up in Washington, D.C. I'm always a big fan when Washington beats Dallas. And that happened. But unfortunately, the Bears last night looked a little bit like the Dallas team on Sunday. And so
if the Bears could patent averaging 2 yards a carry for, 4 weeks in a row, I think they'd corner the market and nobody would infringe, at least not willfully.
It's also important to point out today that, the reason that I'm so casual is because it's 38 degrees outside here in Dallas. And I understand it's a little bit warmer in Chicago today. Is that right?
Yeah, by about 7 degrees. It's what we call the margin of error in Chicago.
Yes. So for those of you who think that it doesn't get cold in Dallas, we have moments of coldness. Cold is about to set in for you guys in Chicagoland, and it'll thaw out sometime in April, I think. So
that's about right. Yeah.
So tell us a little bit about Vedder Price.
Yeah, Vedder Price is a 300 lawyer firm, very focused on client and client development. We've got 200 lawyers in Chicago, which is where we're based. Firm was founded in the 1950s. We've got offices in LA, San Francisco, New York, Washington, D.C., London, and Singapore. We're really focused on driving value to our clients in an economical, business-friendly way. Our biggest practice areas are labor and employment. We're probably tops in the nation in our labor and employment executive compensation practice. We've got a very niche-y little practice, actually. It's not even that little, which is our global transport finance practice, which is all about buying and selling airplanes and helicopters and things. And I don't know how we got involved in it, but we're the world leader in aircraft financing. And then we've got our intellectual property practice, which is what I'm a part of, focused on, again, delivering value to our clients in really business savvy, economical ways without the overhead of the massive law firms with gold-plated ceilings in their lobbies that clients hate to pay for.
Right, no doubt. So Vedder Price is not just specific. It's not specifically an IP firm. It's a broad-based firm. But so, what's your background, and why did you decide to specialize in intellectual property?
Well, I went to college with the idea of getting a PhD in physics and figuring out why the world and the universe is the way it is, and realized I wasn't smart enough to do that. I'll take you all the way back to fourth grade, because I asked my law students when I teach legal writing at a law school in Chicago, and I asked them the first week, what is the moment when you realized you wanted to be a lawyer? Don't tell me, oh, I don't know, it was around when I was 18. Like, what is the actual moment? I remember There was a time in fourth grade we had read Alice in Wonderland, and after we read the book, we had a mock trial where Alice was going to be put on trial for property damage and trespassing and all this stuff, right, that happened in Wonderland. And I was appointed to represent Alice. And a buddy of mine was testifying as the Mad Hatter, and he was going to testify about like all the damage that Alice had caused. And he was wearing a cast at the time on his arm. And he testified that Alice had broken his arm, which I knew was incorrect because I had broken his arm wrestling with him on a play date a week earlier. And armed, no pun intended, with that knowledge, I totally eviscerated him on cross-examination. And I thought, I want to be a trial lawyer. So this was in fourth grade. So I must have been, like 10 or 11. And then I kind of fell in love with science and physics and math. And as I said, though I fell in love with it, it didn't fall in love with me quite enough for me to make a really good living. And the physics advisor, my senior year, kind of took all of us at Northwestern who were graduating in the next 2 years, kind of took us together and said, here's what the market looks like for getting a PhD in physics. And it was clear that I could get a PhD and do postdoctoral work and probably not feed my family for the next 30 years. I said, well, I think I could go back to that fourth grade dream and be a lawyer, but I still love science. And I still love physics. I still love math. They're still really important to me. And so what kind of lawyer deals with science and deals with physics and deals with how things work? And it's an IP lawyer. I'm very close to technology in my everyday world. I use my scientific background all the time in my job. And frankly, one of the things I love about IP law is, and not to minimize how important it is to my clients, it's just basically about money. I couldn't be a personal injury lawyer. I couldn't be a family lawyer. I don't want to do anything that's life or death. I don't want to do anything where, the lives of individuals are really affected, by what I do in sort of this emotional way. And IP law seems like a really noble way of practicing law. You're helping people protect their ideas. You're helping businesses get from startup to successful. And that really appeals to me. It appeals to all the aspects, the fourth grade lawyer to the scientist to the person who probably has too much empathy to do kind of any other kind of law.
I had a similar revelation in fifth grade when I played Daniel Webster in the play The Devil and Daniel Webster. And that's when I realized that I didn't want to be an attorney, but that I liked being on stage.
You were going to say you liked being the devil, but
yeah, right. Well, and my kids would probably agree with that. So all right, let's kind of give a baseline definition here. What exactly is intellectual property and why is it important?
Yeah, intellectual property is the right to exclude others from doing something. So if you think about real property, which is a concept everybody has, when you own real property, you can build a fence around your property to keep people from coming in. Intellectual property is that fence. When you have an idea, the intellectual property laws provide a fence around that idea to prevent other people from making, using, or selling whatever it is that you've invented. So if you just think about intellectual property as that fence around your idea, much the way that you can build a fence around your property to keep people from trespassing, that's what intellectual property is. And in the business context, it's important because if you are different and your difference is driving value, right? If we all made the same thing, we all made commodities, the only way to be successful is to drop your price, right? Because you couldn't compete otherwise. You have no other difference. That's not a great business model unless you're humongous and have economies of scale. Very few companies are big enough to do that. So you have to be different. And how do you stay different? Well, you got to keep people out of your yard, basically. And that's what intellectual property law enables you to do.
Well, that's interesting. One of the first things we do when we engage with a client is we go through what we call the TRA, or the Transition Readiness Assessment. It's kind of a scale that we use to determine how ready a client is for that eventual transition. It's our belief that, and it's been proved out through history, that every business on the planet will eventually transition. And so when we're going through this questionnaire and talking with our clients, one of the first things that I ask them is, tell me about your intellectual property. And so many of them claim that they have no intellectual property. And so, but they also claim sometimes that they're innovative. And so, what do you make of this disconnect between telling me that there's no intellectual property, but they're an innovative business?
Yeah, it's all about where you build that fence, right? And how you build that fence. If I'm innovative, that means I have something that you can't do, or that you can't do as well as I do. And the way that I make sure that you can't do that as well as I do is I keep it a secret. I keep it to myself. Nobody else knows it. That's a form of intellectual property, because it keeps people from copying and doing what you do. And so that know-how, that trade secret, that innovation is a form of intellectual property. I think when you ask the question to somebody, what intellectual property do you have? Their mind immediately goes to, well, I haven't filed for any patents, and I don't have any registrations with the trademark office, therefore I have no intellectual property. That's absolutely not true. And in fact, most of the intellectual property across the world is in the form of unregistered know-how and trade secrets. The most valuable intellectual property in the world, I would argue, is trade secret. Coca-Cola's formula. They would never patent it, because in order to patent something, you have to make it public. The way, just to back up for a second, the reason why the Constitution awards patents is to encourage disclosure of technologies. The Constitution says that in order to progress the useful arts and sciences, Congress can make laws that will award to inventors and authors a limited monopoly. So it's that progress of arts and sciences, which means the quid pro quo, the exchange for getting a patent, is you publish your technology. And if it's worthy of a patent, you get that limited monopoly, right? You get that right to exclude, but you have to publish it. And the reason you publish it is so other people can learn. Same reason that scientists publish journals, publish articles, so other people can learn and then build on it and even design around it, which, is funny. I hear clients get very, very upset when their competitors design around their IP as if they were doing something nefarious. And I have to explain to them, no, that's really what the system is supposed to do. When you design around something, you innovate around it, you create more innovation. So that disclosure is part of the process. Coca-Cola would never disclose their formula for a 15 or 17-year monopoly. The longer they can keep it secret, it is good as long as they keep it secret. And so I think the disconnect is folks just don't think about the things that they know that their competitors don't know, that drives their value and their difference.
So trade secrets are different, I guess, from patents and trademarks and various things like that. But yeah. So can you protect the trade secrets, even though let's just use the Coke example, you're right that they don't want anybody to know the formula. I think of the Chick-fil-A recipe for how they make their chicken. They don't want anybody to know that formula, but
KFC's 11 herbs and spices. You don't know what those 11 herbs are. You don't know what combination exactly.
And so is there a way to protect these trade secrets even without patenting them or trademarking them?
Yeah, well, absolutely. Right. The trade secret is on the opposite side of the spectrum from patents, because as I said, the patents require disclosure. Trade secrets require secrecy. Going back to what the Constitution says, which is patents exist to progress the useful arts and sciences. So if you think about kind of innovation and science and how that advances, the strong public policy is disclose, right? Scientists are supposed to disclose their innovations. They're supposed to publish articles, right? That's how science works. So there is a policy against keeping your best invention secret, right? It stifles innovation in a way, because it prevents people from learning about what you're doing and making it better. But it's still economically valuable. And so in order to protect your trade secrets and your know-how, they have to be kept secret. If you are not careful about putting reasonable procedures in place to make sure that it's kept secret, the court won't protect it for you. So a lot of trade secret cases where somebody is claimed to have misappropriated a trade secret, which could involve an employee switching to a competitor and taking that knowledge with them, all the way to not having a non-disclosure agreement and just being in a brainstorming session and you're letting things go without a non-disclosure agreement. And then you claim, well, this person took what I told them. If you didn't take the steps to protect it, the court won't protect it for you. So it's critical that when you identify those things that bring value because you know them and somebody else doesn't, that you have procedures and policies in place that make sure that that's protected and maintained secret. It's employee non-disclosure agreements. It's using the right non-disclosure agreements with your partners. It's making sure that information is isolated in a database that, you know, not everybody in the company can access. I mean, if you ask Coca-Cola how many people even know where the vault is that contains the formula, my guess it's on one hand and maybe even like one or two fingers, right? If everybody knew where that formula was, you couldn't protect it, right? You couldn't physically protect it because you couldn't prevent somebody from stealing it, but the court wouldn't protect it for you because you haven't shown the court that it was important enough to you by not implementing reasonable procedures to keep it secret. So where I think a lot of companies who rely on trade secrets fall down is they don't identify what those trade secrets are, and then they don't put policies in place to make sure that they're protected and kept secret. And that's really important.
So is that some of what you would call the common mistakes that companies make when it comes to protecting and failing to protect their intellectual property?
Yeah, I think that's among the biggest, because most companies have know-how, right? Very few companies have patents, and the ones that do probably don't have a lot of them because they're expensive to get. But they almost all have know-how, and they don't think about what they need to do to keep that know-how protected and to make sure that if somebody steals it, the court will enforce it for them. And so that is a big failing. Sometimes it's even more fundamental than that. They don't know what their trade secrets are. You know, Bob in the manufacturing plant knows exactly which knobs and levers to turn to make that machine run correctly. That is a critical trade secret for the company. If that machine doesn't run correctly, you can't make product cheaply and effectively. But if Bob gets hit by a bus, Bob doesn't come to work one day and your machine is down, if Bob quits or even you lay off Bob and he wants to go work for another company, you have those protections. If you want to spin off your company and a buyer says, all right, where is your value in your company? You say, it's in our trade secrets. You say, what are they? And you go have them go talk to Bob. What if Bob says, wait a second, you're selling the company? I don't want to go talk to anybody. If you sell this company, I'm going to get fired. I know how this works. He doesn't want to share it with anybody. And now it's too late to get it from him. He doesn't want to cooperate. He's going to take his early retirement and walk away, right? So you've got a buyer who's willing to give you value for your trade secrets if you could only tell them what it is, right? And most companies don't have that information organized in a way that would enable them to get value for their trade secrets.
You know, that's there's a lot going on here. I want to unpack just a little bit. So, you know, in today's day and age, it's way simpler or more simple, of course, to reverse engineer stuff than it would have been 100 years ago, right? I mean, you can take Coke and put it into some test tubes and put it in a lab, and they can kind of, you know, re-engineer, reverse engineer the formula. You can do that with software and things like that. And if you don't have that patent, what's to prevent somebody from doing that kind of thing, and what protections can you get in the company for the trade secret if it's not registered or trademarked or patented?
Yeah, Tom, it's a classic question that a company has to be mindful of. Is this something that is better protected as a trade secret, or is it something that we should patent? If it's something that's easily reverse engineered, it makes no sense to keep it as a trade secret. Now, Coca-Cola's formula is not easily reverse engineered. Software, you could, there's probably a million ways to skin a cat in any kind of software application, right? And you don't have to copy the code in order to write something that does the same thing. So software, sometimes trade secret, sometimes not. It depends on how sophisticated it is. An AI algorithm may be a trade secret because that's really hard to back out. Other software is protected by copyright, and you publish the code, you register it with the Copyright Office, and that's published, and that's copyrightable. So you always have to think about the two things. Is one, how hard is this going to be to reverse engineer? Because if it's easy to reverse engineer, trade secret's not going to work. It's only as good as your competitor's ability to reverse engineer. And then two, would I be able to detect if somebody else were infringing? So if somebody else is using a process and they've figured out how to turn the knobs and the levers on the machine, and I get a patent on that, how am I going to determine if somebody else is infringing unless I'm actually in their manufacturing plant, looking at it and seeing what they do? And if I'm never going to be able to adequately detect infringement, even if it's reverse engineered, I probably take that chance that I'm going to keep that as a trade secret rather than just teach them what I already know. Even if it only takes them a year and a half to reverse engineer, sometimes a year and a half head start, first in market, is incredibly valuable. And so those are the two things that you always think about. But if you can detect infringement and it's easily reversed engineered, then you probably want to consider patent protection, assuming that whatever it is worth the cost of getting a patent, which is not insubstantial.
Right. Well, this is complicated, and you're building a great case for why every business owner should at least have a conversation with someone like you who understands how to protect that property. You've given me stuff here that I never knew. I didn't realize kind of the intent of the Constitution in regards to patents and to get the information out there to advance arts and sciences. And so that is an interesting lesson on constitutional law. So before we take a break, though, it occurs to me that really every company probably has some intellectual property. So, but are there companies that are too small to worry about it?
No. I mean, the short answer is no. And if you think about it, and again, if we go back to this idea of that intellectual property protects your difference, right? So that it keeps competitors away from the thing that is bringing value to you, right? Your innovation needs to drive value. If the thing that's making you different isn't enabling you to charge higher prices or getting more people to call you, then your difference isn't being protected and isn't being adequately leveraged. And that happens when your intellectual property strategy isn't aligned with your innovation and business development strategy. So if you think of yourself as a small company where you've got a market advantage because of something that's different, right? It is probably more important that you protect that difference, because if you don't protect that difference and you kind of, you devolve to sort of a commodity type business because other people are doing it, smaller companies won't survive in a commodity type situation. The companies that are great at sort of commodity have massive economies of scale. They have much better cost structure because they're buying raw materials at such a lower price because of their volume. A small company in a commodity business will never survive. The economics won't work out. They're just not big enough to compete with the bigger companies who can survive on a much lower profit margin because they're selling so much more of it. So if you're a smaller company, intellectual property is almost more important to you because your slice of the pie is potentially more at risk. And when that pie starts to shrink, your slice becomes even smaller, and you've got to defend that slice of the pie. And so I would say, if you are a small company without an intellectual property strategy, and again, that doesn't mean giving a lawyer like me a 6-figure budget and saying, go patent everything. It means identifying what your innovations are and figuring out how that aligns with your business, how you can use strategic patenting to make sure that you get volume commitments from your biggest customers. Those are the kinds of things that you do a targeted intellectual property approach that really helps a small company survive.
That is a strong argument, but so for our listeners, do not despair. When we come back after the break, before we end here, we're going to talk a little bit about an assessment that you can take that Dan will be happy to provide to you, and it's a short questionnaire to kind of start thinking about these things. So we're talking with Dan Schulman. We'll be back after a quick break.
Every business will eventually transition, some internally to employees and managers, and some externally to third-party buyers. Mastery Partners equips business owners to maximize business value so they can transition their businesses on their terms using our 4-step process. We start with a snapshot of where your business is today. Then we help you understand where you want to be and design a custom strategy to get you there. Next, we help you execute that strategy with the assistance of our amazing resource network. And ultimately, you'll be able to transition your business on your terms. What are you waiting for? More time? More revenue? If you want to maximize your business value, it takes time. Now is that time. Get started today by checking us out at www.masterypartners.com or email us at info@masterypartners.com to learn more.
We're back with Dan Schulman, an IP attorney with Better Price in Chicago, and we're talking about protecting your intellectual property and why it's important when you think about maximizing your business value. So, of course, we're recording this podcast during COVID-19, the pandemic that kind of set the world on fire this year, and all things sort of changed. So what are your clients doing differently in the innovation space during the pandemic, Dan?
Yeah, it's I'm going to answer this in 2 ways, because one is sort of the pandemic influenced things that they're doing. And then there's a broader kind of how IP strategy gets affected during recessions, which this is. So one is, unfortunately, there's not a lot of new product introductions going on, right? Because the market is so depressed. Nobody's going to be introducing new products in a market like this. So that means that some of your trademark filings are down because you're not establishing new brands, because you're not introducing new products. And some of your patent filings are down because there's no pressure to file a patent. You have a certain period by which, once the invention becomes public, your patent needs to be on file. If that trigger isn't happening, there's not really a pressure to file new patents, and plus it's expensive and folks are watching their wallets. So patent filings and trademark filings are definitely down. What I worry about is whether innovation also is down, because the two things don't necessarily have to correlate. And in fact, what I've been talking to my clients about is trying to really think strategically and zig when your competitors are zagging. And a really good example.
Is that a technical legal term, zig, when they're zagging?
Yes, it's the metric zig versus the English unit zag. Yeah.
There you go.
And so I learned that as a first year law student. I think in a bar somewhere. So so here's in the office. Okay, that's kind of goes without saying. Even the ones that are coming back to the office, it's on a limited basis. Well, who that really affects in the product development world are those people that need to be on a pilot line or need to be in a prototyping lab. Because in the bricks and mortar world, where you're actually making something that you're selling, that's the last stage of product development. You have to build a prototype, right? You have to get on a pilot line and see, can you build this? How does the tooling work? If you're not getting into your plant, right, because of restrictions, if you're not getting into the prototyping lab because of restrictions, you've got product development people who might spend 10 to 15% of their time doing that kind of work. if you're keeping them on the payroll, what are they doing with that 10 to 15% of their time when they're not physically doing things, right? Because they're working from home. My recommendation for companies who, and I hope people are keeping their product development people employed. I mean, I hope they're keeping as many people employed as they can. If you've got people in product development who are otherwise have time on their hands, let's say, it's a perfect opportunity to do pure white space innovation. And in a lot of companies, there's this tension for product development and innovation, which is, I don't want to support an innovation that the customer hasn't expressed an interest that they'll buy. Which means that pure kind of white space, real paradigm busting new products that don't exist, so you don't have a customer commitment for them, don't always get support from the business because it's expensive to start a new product. 75% of new products fail. And so when you're really going to try and zig when the market is zagging, you're really taking quite a risk, right? And so what happens is innovators get discouraged and don't really pursue pure innovation for innovation's sake. Well, this is the perfect time to let them do it. They've probably all got those ideas in their head that they've been holding on to for the last few years because they thought, my manager will never support me working on this totally new project that we don't have a customer commitment for, right? But why not get everybody together, and I've been supporting doing this, and do what we call an innovation mining session. Have people bring those innovations to a group, and there's a whole lot of prep work that you do in advance to make sure that you can properly score and categorize and prioritize innovations. But let's all talk about all these new innovations that people are working on. And maybe you come out of the pandemic with one or two things that just like nobody had thought of that could be absolute game changers for your industry. And when you get back online, when we're all back to work, God willing soon, you're going to be ahead of your competitors that are just worried about treading water because you'll have new products past the kind of early vetting stage, ready to go into development. That's going to be a huge advantage for a company. And so I've had a couple of clients that have really latched on to that, and we've started to do the work to do those innovation mining sessions. And I think there's no downside, really, because as I said, those innovators are kind of sitting on their hands for that 10 to 15% of the time when they're not doing the things they would normally be doing. So utilize them. They're the smartest people in your organization, right? They're the most creative. And that's what I would encourage more companies to do, to really think strategically about how can I turn the lemons into lemonade.
Yeah, that's a new term that I hadn't heard before, which is actually surprising. I give a talk on creating a culture of innovation. I've delivered that dozens of times over the last five or 6 years. But this term innovative mining session or innovation mining session. Yeah. I owned a software company for many years, and we used to do at least on an annual basis, usually twice a year, what we called Blue Sky, and it's think of all the ideas that we could do, right? Mm-hmm. So tell me a little bit more about this innovation mining session, because that sounds very exciting.
Yeah. So as I said, everybody's got these ideas, and they're probably not publicizing them, right? So what you do is there's several steps. One is the prep work. Okay. So whoever's going to lead the mining session, it could be me, it could be somebody in product development. There are people that specialize in new product development who can do it. But I've done it in the past for companies that I worked for. You talk to strategic thinkers at the company, the heads of marketing, heads of business development, presidents of the business unit, finance, sales, and you start by figuring out what are the key criteria to product launch success: scalability, manufacturability, cost, time to market, all of these different factors that go into whether or not you're going to advance a product, through the process. And all of that in advance. And those become basically your criteria. You do all that prep work in advance. You have, if it were in person, you'd bring people into a room. These days we're doing it over Zoom with breakout sessions. And you tell people, bring your ideas. and you present them. You might go in breakout rooms now where you might categorize the ideas based on, particular type of product or service, whatever it is, however you want to do it. You have breakout rooms where people talk about, try to improve on it. You brainstorm on it, move around the breakout rooms so everybody's involved. It probably takes about a half a day or a day to do this. You come out of that with a bunch of ideas that are prioritized. You score them based on the pre-work that you did. And you identify, your top 2, 3, 4, 5 things that are really promising. Ideally, you hand that off to somebody like me, to an IP lawyer, who does the search and says, okay, you have freedom to practice, because you don't want to advance a product that other people have patents on and that you can't make, right? So you need to do the clearance work on those. And then you might also, at the same time, do a patentability assessment. Can I get my own patents on this? I mean, if this is really groundbreaking, I'm going to want that fence that I talked about. And once you combine sort of the business score with the legal right to practice and protectability, and you identify those things, you are ready to hit the ground running when the pandemic is over. And there's things you can do even before, the pandemic is over in terms of product design and CAD and all that stuff. But you've put yourself in a position then to succeed. And these are things that you can do, that businesses often do twice a year, just to kind of flush out the stuff that folks have in their lab notebooks that they're afraid to tell their manager about because they won't get support for it. And you talked about building a culture of innovation. And I spent a dozen years as a chief IP counsel for a $14 billion consumer packaged goods company. One of the things I learned there was how important it is to make the innovators feel empowered to innovate, which seems obvious, but there are so many ways that you stifle a culture of innovation by keeping your innovators from doing things that are innovative. And managers telling product development people, we don't have a customer commitment for that, so stop working on it, is a sure way to create a morale and stop your innovators from thinking creatively. So if you're going to do that, offset that by once a quarter, twice a year, having these innovation mining sessions so that at least the innovators feel empowered to innovate. That is one of the easiest and most effective ways of creating that culture of innovation. And right now, with morale being what it is, you want to do everything you can to foster a culture of innovation, because that's what's going to bring people together and out of the pandemic. It's being innovative, where people are already being innovative in the ways that they run their business and adapt.
Yeah.
Don't let that opportunity go to waste.
And not only that, I love it when in this podcast, we kind of give glimpses into what a lot of times people perceive this is what the bigger companies are doing. But those are kind of the best practices that small businesses should be able to do as well. Maybe it's not as big of a process as it would be at a bigger company, but small businesses should be doing this kind of an innovation mining session, a couple of times a year, because you never know what you're going to uncover with your people. And that was a great outline. I would encourage you to go back and listen to those steps again to our listeners and kind of create your own model for being able to do this. But don't forget, if you're going to come out with something that is very innovative, you ought to be in touch with someone, certainly like Dan, to make sure that it's not already protected some way. So, Dan, that is.
I should say, Tom, just to shameless self-plug, I do have innovation mining proposals that I can send to clients that outline, some of the baseline costs. Of course, there are different ways to bill for it on an hourly basis, on a fixed fee basis. And as with everything in life, everything's negotiable depending on what the business wants. My view as a lawyer, and this comes from being somebody who was the client for a long time because I was in-house, is I'm not in it to make money for myself at the expense of my clients. If it's not a win-win, I don't want to do it. And so if people want to reach out to me to discuss an innovation mining proposal that outlines all of these steps and what it takes and the timing and potential costs, I'm happy to share that with anybody who wants to reach out to me.
Awesome. That is great. We'll give your contact information in a bit. And that is a common theme that I find among Provisors members, is that they're really more interested in taking care of their clients than they are in taking care of their business. And I love that. It's kind of a servant leadership mentality. Dan, what lessons have you learned as an IP attorney that you wish that you had learned earlier in your career?
The next one that I learned. That's sort of the flippant answer. You find meaning in everything in life, right? And I don't know if everything happens for a reason or not. I'm not sure that I'm that fatalistic, but when things happen, you have to find meaning in them. And I took a path from being in private practice for my first 7 years. When my kids were very young, and I wanted to make sure that I didn't shortchange them, because I always wanted to be a dad much more than I wanted to be a lawyer. I went in-house and had that lifestyle that was really conducive to me coaching Little League and going on travel soccer tournaments, and being around for my kids and being home to make dinner for them, and all that kind of stuff. And I learned a ton as an in-house lawyer that I would have never learned being in private practice. And I'm immensely grateful for those lessons. And in terms of being in-house, some of the things that I learned were, I didn't have all the answers, and I thought I did. It's sort of, one of the things that I struggle with in life, probably not unlike a lot of lawyers, is tend to sort of be a know-it-all and think you have all the answers. Frequently wrong, but never in doubt. And you really have to build. You learn humility through life, and it makes you a better person. It makes you a better lawyer, for one thing. But when I came into my in-house job, and they didn't have any chief IP counsel, and everything was kind of a train wreck in terms of IP, and I rocked a lot of boats and probably pissed off a lot of people by telling them that all the things that they were doing for years that they didn't know they were doing wrong, they were doing wrong. And I had to learn to be a lot more diplomatic as my time went on. But what I learned was that nothing engenders trust better than having good results and being right more than you're wrong. And if you deliver for people, you'll earn their trust. If you don't lie to them, if you're honest about what you can do and what you can't do, and if you're right nobody's going to be right all the time. But if you're right a lot more than you're wrong, people will trust you. And the only way to be right more often than you're wrong is to learn when you're wrong. I'm reminded of one of the many Groucho Marx quotes that I sort of build my life around, which is try to learn from my mistakes, because you'll never live long enough to make them all yourself.
Right.
And I really try to learn from every mistake. And that's why I say, and it's only partially flippant, that the next lesson I learn will be the one that I wish I had learned earlier. But there's going to be a next lesson, and I hope there is, because I'm not done learning.
Yeah, that's awesome. Yeah, I think the quote actually was Eleanor Roosevelt, and I think she said, "Learn from others' mistakes, because you'll never live long enough to make all of them yourself."
Maybe Groucho Marx didn't. Maybe either she stole it from Groucho Marx or Groucho stole it from her. I can't vouch for either one.
No doubt. Yeah, I'm definitely. You can fact check us both on this, but I did learn a new phrase here that applies to me. Frequently wrong, but never in doubt. I love that. I'm gonna use that.
When I was a very young lawyer, I had a much more experienced lawyer say to me, and this was life-changing, career-changing for me, because I was like that. And he said to me, "I wish I was as sure about anything as you are about everything." And I was I was just fresh out of law school, very wet behind the ears, and I thought, wow, I don't want to be that kind of guy. And that was, you learn from the people that have done it before, and that was transformative for me to hear somebody tell me that.
Yeah, that is one of those great lessons that apparently you took to heart. So tell me the typical profile of one of your clients.
The only profile that they have is innovation is important to them. I have startups that have negative revenue. I have clients that have 15 to 50 billion in revenue. I have clients with 5 employees and clients with 150,000 employees. I have clients in software and tech, and I have clients that make plastic bottles and bags. The common theme is they need to get value for their innovation in order for their business to survive. And if that's the case, I can probably help you.
Perfect. That clears it right up. And it's really kind of interesting that a lot of companies kind of get in that, the older they get in that mindset that, well, we're not really innovative. We make this or that. You're a good example of bottles and bags. There are all kinds of innovations going on in packaging, right? And so if you are stuck in the thought process that you're not an innovative company, then you really need to go. And I think my talk on creating a culture of innovation is available on our YouTube channel. Go take a look at that and realize that every company on the planet can be innovative. And if innovation is important, that's a great common denominator that you have for your clients. So tell us what sets you apart from other IP attorneys.
Yeah, well, the big thing, as I alluded to, was I was the client for a long time. So I learned how to protect innovation and find value from innovation with a shrinking budget down to zero. Living in fear the CFO was going to come running into my office complaining about the legal bills, which happened, frequently. So I don't have the freedom that most outside counsel think they have. Write me a blank check and I'm going to protect all your IP. And that really meant building a culture of innovation. It meant empowering innovators. It meant reforming how the sales department does their contracting to make sure that they're not giving away innovation. It means, doing assessments of where you are from an IP standpoint. Doing things that don't cost a lot of money, like, as I talked about, having a system to document your trade secrets. And one of the things that I do with my clients now and with some prospective clients is really kind of leverage everything that I've learned about building an IP program, because that's really what I did, coming into a company that didn't really have an IP program and building one from scratch and keep doing it as the private equity company would bring in more companies and I'd have to do this all over and over and over again. And I've created an IP questionnaire, which is like 2 to 3 pages, which just helps clients plain English, because as you said at the outset, if you ask a company, what intellectual property do you have? You get none. That's not really helpful. So you have to ask the questions in plain English. And I've put together a questionnaire that if a client fills that out, I can talk to them. And I've been offering this to clients, free 30-minute assessment. You send me back your questionnaire and I can help you figure out what you need to do and what you can do better. And it's a laundry list of, things that are low-hanging fruit. You can do this better. You already have a commercial lawyer looking at your sales contracts. Why don't you have an IP lawyer looking at it? And I'm going to give you an example. This is just something I've been working on this week. Had a client who had a purchaser send them a 35-page master purchase agreement for all these different kinds of products. And these are products that are going into bigger products that the purchaser was selling. And, it's a typical one-sided sales contract, even though it's 35 pages, but that's sort of how these master purchase agreements go. You would not believe on basically every other page, there was something that impacted intellectual property. There was, requirements to grant licenses to your technology to enable them to go out and second source. But the licenses were so broad that they would enable themselves to put another company in business and transfer all of your know-how to them, because they wanted all the rights to all of your background intellectual property, just because they were buying products from you. They wanted to suggest modifications to products and then own all of the intellectual property that goes into those modifications, even if they're things that you would do all the time, because how to, as I said, turn the levers and turn the knobs on the machines, right? But they wanted to own all of that, right?
Wow.
And you're shocked, Tom, but I can tell you that this is pretty much par for the course with big purchasers with leverage. I dealt with this when I was in-house with companies like Coca-Cola and McDonald's and Starbucks and Walmart and Procter and Gamble and Clorox, right? That was always the starting point for them, were these massive master purchase agreements that sort of had hidden in them really dangerous IP clauses. And if you didn't have an IP lawyer looking at them, and they weren't always in the section that said intellectual property, they were all over the place. And that's a surefire way to destroy your value of your company, and a surefire way to, as I said, kill morale, because your innovators will look at what your competitors do with your intellectual property and go, how did we give that away? If you ever try to sell the company and somebody does due diligence or reads that contract and go, you don't have anything anymore.
And they will.
Very
and
typical.
they will. If you're selling to a bigger buyer, they will read those contracts.
So just doing that assessment, and then, identifying, there may be things that you can strategically patent. There may be trademarks that you haven't registered that you probably should do better at protecting. There's always ways you can protect your trade secrets better. And so that's what really differentiates me, is I have that toolbox of knowledge from being in-house of things that most outside counsel have never had to deal with. And because by the time you call them, you're already resigned to writing them a big check. And that's sort of not my style. I'd love for somebody to write me a big check, but that's not ultimately the right solution for all of my clients.
Right. Well, and that's, you make a great point here that, as I tell our clients all the time, never, ever, ever, ever sign an agreement without having an attorney look at it. And now you've given another reason why you might want to, you may have a great business attorney, but you ought to ask him, do they have an intellectual property practice? Because we want to make sure that we're protecting that as well. And offering the free 30-minute assessment. All right, listeners and viewers, you got a free 30 minutes with the expert, the Mac Daddy on IP here. And so I would take advantage of that. I hate that we're running out of time, but one last business question here. As you know, and our listeners know, this podcast is all about maximizing business value. So what is the one most important thing that you recommend business owners do to build long-term sustainable value in their business?
Empower your innovators to innovate, right? I mean, it's if you do that and you build that culture of innovation, you will get value for your innovation. And if you're not getting value for your innovation, it is really expensive to innovate if you're not getting value for it. I'm sure there's a lot of other things to build sustainable business, but I'm an IP lawyer, so it's sort of like, to the hammer, every problem looks like a nail. But I'm going to tell you that from my perspective, getting value for your innovation, and that means building that culture of innovation. And Tom, I love that you've given that speech. I've given it too, from the IP lawyer's perspective, how to build that culture of innovation. It's critical. And if you do that, you'll find value.
You will probably not be surprised that we make a very big deal in that presentation about encouraging folks. The goose, right? How geese fly and encourage one another with their honking, and encouragement to empower the innovators to go and do their work. That is a golden nugget right there. Of course, everybody who listens and watches this podcast on a regular basis knows that I always ask a bonus question, and I'm very excited to get the answer to this. So, Dan, what personality trait has gotten you into the most trouble through the years? I think we've heard a couple of things that you've mentioned earlier, but what's the one that you would say has gotten you into the most trouble? Yeah,
well, it's certainly the one I alluded to, which is you're never as smart as you think you are. My family, my parents, certainly my ex-wife will tell you that, not my current wife, because I'm a changed man, but we'll tell you that, being a stubborn, condescending know-it-all is not an attractive quality. And you as you go through life, and you get to be, you're the same size fish, but the pond gets bigger. You better learn modesty. You better learn humility. you can't learn anything until you admit that you don't know something. And so humility is an essential quality to being a lifelong learner. And I am a strong believer in lifelong learning in every area. And so I am, I still fall into, being competitive, wanting to be, the smart aleck, wanting to have the quickest wit and the best comeback. And, but, I really, really try to be as humble as I can. And that doesn't mean, being shamefaced and saying you don't know anything. That's an extreme that, you have to have confidence, you have to be secure, but you got to be humble. And that's an area where I think it's probably a common affliction for lawyers. I try on a daily basis to rein that part of me in.
Yeah, lawyers and business owners, have that common affliction for sure. So I am so glad that you learned your lesson early. I think it may have also been Groucho Marx or somebody that said youth is wasted on the young. I wish we had all the knowledge that we have at this age, when we were full of piss and vinegar when we were 24 years old, right?
Yep.
So how can our viewers and listeners get in touch with you, Dan?
Yeah, best way is email. So you could email me at dshulman, DSHULMAN, at vetterprice.com. If you go to vetterprice.com, you'll find my bio there. You'll learn all about our IP group, other things that Vetter Price does. Really a fantastic economical firm. I've always believed that kind of the mid-size firm is the best value. I always thought that when I was a client, and I think we really embody those principles. So go to vetterprice.com, email me directly. My bio is up there. The way to contact me is up there. Tom, you know how to reach me. If your clients reach out to you, I'm sure you'll put me in contact with them. But smoke signal, semaphore, little tomato cans on the end of a rope, whatever works.
Perfect. Well, thank you, Dan. This has been an amazing conversation, and I've learned a lot today. Thank you for being our guest. You can find Dan Shulman at Vetter Price, VEDDER Price.com. You can find him on LinkedIn, and as always, you can reach out to me, and I will be happy to make a warm introduction. I would encourage you to take advantage of filling out that very short human language questionnaire, sending it back and taking a free 30-minute consultation with Dan. You will be so glad that you did. This is the Maximize Business Value podcast, where we give practical advice to business owners on how to build long-term sustainable value in your business. Be sure to tune in each week and follow us wherever you found this podcast. Be sure to comment. We love comments and we respond to all of them. So until next time, I'm Tom Bronson, reminding you to protect your intellectual property while you maximize business value.
Thank you for tuning in to the Maximize Business Value podcast with Tom Bronson. This podcast is brought to you by Mastery Partners, where our mission is to equip business owners to maximize business value so they can transition on their terms. Learn more on how to build long-term sustainable business value and get free value-building tools by visiting our website, www.masterypartners.com. That's master with a Y, masterypartners.com. Check it out.
That was perfect. I wouldn't make any changes on that.